Good evening and welcome to our special Connecticut Mirror event with our friend Linda Greenhouse as we talk about the Supreme Court. I'm John Dankosky. In just a minute, I'm going to let you know how you can ask questions of our Supreme Court expert. But first, I've got some news for you. The Connecticut Mirror has hired two new reporters. Andrew Brown is an investigative reporter. Erica Phillips is our first ever economic development reporter. We see these beats as vital to telling the story of Connecticut, to holding government accountable, and to charting the economy of our state. And we've got more growth planned in the future, but we just can't do it without you. Now, I know that many of you have contributed to the Mirror in the past, but if you haven't, I encourage you to do so right now. You can go to ctmirror.org and click on the donate button. There you can make a monthly recurring donation to support nonprofit, nonpartisan journalism. Thanks so much. Now, speaking of nonprofit, nonpartisan journalism, we want to thank the many readers of VT Digger, which covers the Green Mountain state of Vermont under the banner News in Pursuit of Truth. Now, with a slogan like that, you can tell why we're friends. Welcome to everyone from Vermont tonight. If you've got questions during our program, please use the Q&A function, which you can find at the bottom of your screen. There is a chat too, which you can use to have a dialogue amongst yourselves. But if you want me to ask Linda a question, please put it in the Q&A. Now, to introduce our guest who joins us for the second time at the end of a Supreme Court session, Linda Greenhouse is a longtime Supreme Court reporter and columnist with the New York Times. She's a Pulitzer Prize winner and one of the leading observers and scholars of the court. She has a new book coming out this fall titled Justice on the Brink: The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and 12 Months That Transformed the Supreme Court. We'll be talking about her book in just a little bit as well. But first of all, I want to welcome back Linda Greenhouse. Thanks so much for being here. It's great to see you once again.
Oh, my pleasure. As you know, I am a daily reader of the Mirror and a donor to the Mirror, so I'm happy to do this.
We're really glad to have you once again, and obviously very happy to have you as a donor as well. So we talked last year after a very interesting Supreme Court term, and this is another interesting one. It maybe didn't get the same sort of headlines, but there certainly was an awful lot of change in the court this year. Let's just step back before we get into some of the details, Linda. And what did you take away from the Supreme Court term more than anything else?
Well, of course, the question going into the term, I mean, it's hard to believe that a year ago, Ruth Bader Ginsburg was still alive, right? Her death in mid-September ushered in the prospect of major change. So President Trump has put 3 justices on the court, as people know, 3 justices who are to the right of the Chief Justice, John Roberts, who's a very conservative judge. So really the question going into the term was, is it still going to be the Roberts court? He's got 5 justices to his right, 3 to his left. The 5 don't need him. What's going to be the deal with this? I think my takeaway is he actually did manage to continue exercising a fair amount of leadership, not on everything. They ran to his right on religion, which I think was a major takeaway from the term, what the court did to the government efforts to keep the public safe by placing capacity limits on worship services. Roberts believed in deferring to the experts on that. And the 5 justices to his right said, you know, nuts to that. Worship is worship. We don't care what the experts say. I mean, I could go on about that if people want me to. But on what I'd say was the core of his project is in part voting rights. That is to say, voting non-rights, one might say. He actually, of course, he wrote the major Voting Rights Act opinion back in 2013, Shelby County. And he didn't write the one this time, but he assigned it to Sam Alito, and it really carried out, I'm sure, his preference in terms of a very, very stingy interpretation of what was left of the Voting Rights Act after Shelby County. So, you know, those are my major takeaways. Obviously, there's a lot to discuss, and there's a lot of nuance. Any term of the Supreme Court is really a snapshot in a very dynamic process. But I'm happy to talk more about any of these things.
Well, maybe though we can just spend a little bit more time on this idea of the Roberts Court with 5 justices, as you say, to his right. You have already said a bit about the leadership that he displayed, in some ways more so than others. Talk a bit more about the role of a Chief Justice when you have a court that is balanced in this particular way, when, as you say, Linda, they don't need John Roberts to come along with them if they want to get something done.
Right. Now, the 5, of course, are not all fungible. These are 5 very different individuals. And so what we saw was Brett Kavanaugh kind of gave the chief cover in a number of cases. So did, in a way, Amy Coney Barrett. That was a bit of a surprise, I think, to many people. People, given the really norm-breaking way that Donald Trump foisted her onto the Supreme Court and really nominated her before Ruth Ginsburg had been buried, literally. I think those of us on the moderate to progressive side of the street really expected the worst, and I don't think that occurred. She obviously is a quite conservative individual. She's smart. She's picked her spots. They didn't give her a whole lot of work to do. She only wrote 4 merits opinions. I think she actually lost 1 case. It was not one of the high-profile cases. But, you know, so the 5 to Robert's right were not always on his right. They were in league. Some of them, at least, were in league with him in certain cases. So it's a complex picture. But I think I'm just projecting. I'm just guessing that by the end of the term, he maybe was a little bit relieved that things didn't go worse for him.
That has been a lot of the commentary following this term and during this term as well, though, that these 5 very conservative justices aren't always of a group and that they are very different. Did you see that playing out in more ways than maybe you expected? Some new alliances forming, ways in which Gorsuch and Alito would break off from the pack in some rulings. How did you view this group of conservatives?
Well, you know, the court decided 58 cases this term with full opinions. They decided a number of other important cases on what's called the shadow docket. These are cases where the court has not formally granted them and it tends to issue orders, you know, Thanksgiving Eve, the middle of the night, whatever. So there were more of those. But I think most of the cases that people are pointing to as, oh, look how unified they were, really, are not the major cases. I mean, they weren't unified at all in the Voting Rights Act case that came down at the end of the term. They weren't unified at all in a major property rights case that hasn't gotten a whole lot of attention. They looked unified in the term's big religion case, which was the case from Philadelphia about whether the city could refuse to renew the contract of a Catholic social service agency that would not consider same-sex married couples as potential foster parents under the city contract. The vote was 9-0 for the church agency, but it wasn't 9-0 on the heart of the matter, which is at what point does religion, I hate to use the word trump, but you know, trump other claims such as a claim to non-discrimination. And there was a lot of angst over that case. And I think what the case ends up showing us is that religion is going to win one way or the other in this court. And that's a major change and a very consequential one. So, as I say, the devil's in the details in a lot of these cases, but kind of pound for pound, it was a very conservative term in the cases that mattered. Out of those 58, obviously the Supreme Court case matters a lot to the people whose case it was, and people who have legal issues pending who will be affected by that. But out of the 58 cases, I don't think there were 10 that really kind of reached the surface of public interest. And of those 10, it was a conservative court for sure.
So you don't buy a lot of what people viewed during this court term, that this was far more moderate than was expected.
No, I don't really. And I kind of, a red flag for me is the kind of, let's find out what kind of term it was by counting by numbers, who voted
Mhm.
with whom and who are the coalitions and all that, because that, when you're counting by numbers, you're assuming that all the cases are the same. And they're not. Some cases really, really matter to how we live as a democratic society. And that's voting rights. And I strongly believe that's the religion cases. And so you've got to, focus on those cases, not the cases that you never heard of going into the term and you're never going to hear about again. So I think, some people have missed the boat, and we love our numbers. We're all, maybe we all grew up as baseball fans and we love statistics, and I think they're going to reveal the truth. But I don't think that's the case when it comes to the Supreme Court.
Well, maybe you could talk a bit more about that, because your newspaper, the New York Times, did a very nice big analysis with a lot of numbers. And there's a chart in here. It says conservative justices most likely to join the Democratic appointees, and at the top of the list is Brett Kavanaugh, 85%, 11 of 13 cases. And someone might read that and say, Brett Kavanaugh didn't turn out to be so, in quotes, bad or good as we thought that he would be, depending on what side you were on. But you say that that doesn't really tell the tale.
It doesn't cut it for me. It really doesn't. I think back to Justice John Paul Stevens, who was an appointee. He was Gerald Ford's only Supreme Court appointee. He was, you might say, kind of Rockefeller Republican of his time. And he issued a very strong dissent in a case called Parents Involved. It was a race case in 2007, and in which he said, the court that I joined in 1976 never would have gone along with this opinion. But he said, every justice who's been appointed while I've been on the bench has been to the right of the justice they replaced. And so the center, there's always going to be a center of gravity. And there's an odd number of justices, maybe there shouldn't be, but there is. So there's always going to be a, quote, median justice, which right now statistically seems to be Brett Kavanaugh. But that doesn't really tell us the essence of what the court is about. And so that's why I push back on the sort of what I call the paint by numbers way to try to understand the court.
Is it fair to say, though, that despite the fact that it's clearly a much more conservative court, the fact that it's a bit fluid, that it's a bit more dynamic, and that you don't have, a Justice Kennedy that you're just waiting to see, is he going to be on this side or this side? And then we're going to know what happens. I mean, at this point, you don't have that central key figure. And I think, those of us who are watching, say, the United States Senate, in the overwhelming amount of weight that a Joe Manchin from West Virginia seems to carry around with him right now, it's very easy to think, is it better to have one person who holds all this power, or to have things a little bit more diffuse, and we don't exactly know who's going to be the swing vote on one case or the other?
No, that's a very fair point, John. It's more like the court that I first started covering when I had the Daily Beat in the late 1970s, where there was a middle of the court, 3, 4, sometimes 5 justices. Of course, it was not as conservative a court then as it is now, but that middle of the court. And so somebody framing a case and going up there to argue a case couldn't just focus on the guy or the woman. It was, before Kennedy, it was Sandra Day O'Connor, who was that so-called swing justice, but really had to frame an argument that was going to appeal to that center core. And I think I think we did see something about that this term. But I'll say something else. I mean, the docket of the term was kind of skewed. The one major missing piece, aside from the voting rights case, which of course is about race, but it wasn't frontally about race, was race. So the court got the appeal in the Harvard admissions case, the claim by kind of a phony put together group of so-called applicants to Harvard that they've been discriminated against in admissions. And came to the court, and I certainly would not have been surprised if the court had taken this case, but they didn't. They didn't turn it down either. They asked for the views of the Solicitor General. They asked for the Biden administration's views, which is a way of kicking a can down the road. And they won't get those views back till probably 6 months from now. And if they are inclined to grant that case, maybe they'll grant it in time to be decided next term. Chances are they may not be in time. So, you know, we didn't see all the hot button stuff. And of course, next term we will. We've got a major Second Amendment gun rights case, and we've got a major abortion case. And so I say to people who say, oh, it's a moderate court, you know, take a nice nap over the summer. They're on recess, and they'll come back and watch that space, and you may not be singing the same tune a year from now.
Well, you've mentioned this a few times, and maybe we can get into this voting rights case. And before we do that, I just want to say, if you have questions for Linda Greenhouse, you can go to the Q&A function. It's at the bottom of your screen there on Zoom. Everyone knows how to use Zoom now, right? There's a Q&A function, and you can just type in your question there. I will get to as many of your questions as possible. I know full well there are some lawyers here. So if you have questions for Linda Greenhouse, please keep your questions brief. I only have so much time, and I can only read so many of them. That's not just for lawyers, by the way. Let's talk about this voting rights case, because so much of the political conversation leading up to the election, during the election, post-election has all been around voting rights, the ability of people to vote a certain way. And right here in Connecticut, I mean, we saw this play out in a very, very interesting way. Connecticut has been terrible, in my view, I can say, in terms of allowing people ease in voting, the ability to vote through the mail. But because of the pandemic, people in Connecticut turned out in record numbers to vote because we made it a little bit easier. We see following the election that some states are trying to crack down and change their voting laws, make it much harder for people to vote. So this ruling on voting rights really came as this issue is being debated more than just about anything else. So maybe you can walk us through that case a little bit and why it was so important.
Yeah, you know, it's interesting. When the case was argued back in the early spring, it didn't get a huge amount of attention. I think it seemed as if it kind of came out of nowhere. And then all of a sudden, of course, we saw what was happening in Georgia, where now it's a crime to give somebody water while they're waiting in line, and you know, so on. And the case gained an enormous amount of salience, basically while it was sitting there on the court's docket. So what is it about? It's a case that really kind of resides in the weeds. It's what a plaintiff has to prove, how you go about proving a Voting Rights Act case under Section 2 of the Voting Rights Act. So Section 2, unlike Section 5 that was disabled in the Shelby County case, applies nationwide, and it sets out a purpose test and a results test. So any provision that has the purpose or effect of impairing the right to vote on the ground of race violates the Voting Rights Act. So how do you go about proving that? And what the court basically held is, well, you know, voting isn't easy. Voting's never been easy. The job of Congress in passing the Voting Rights Act wasn't to make it easy. It was just to make sure there's no glaring overt discrimination. So the two provisions of the Arizona voting scheme that the court upheld, reversing the lower court, which had invalidated them, you know, on the surface, they don't look so silly. One provision said, if you end up voting in the wrong precinct, that's too bad for you. None of your votes will count. Your ballot won't count, even for those offices that don't depend on precincts, statewide offices, national offices, and so on. That was one. And actually, when I lived in Maryland, before I moved to Connecticut, I actually took training, and I was an election judge in a precinct. So I know how these things work. People, for all kinds of reasons, show up in the wrong precinct. So that was one. And the other was if you're voting absentee, mail-in ballot, and the ballot is collected by somebody else that's you're not related to, it's invalid. What the Republicans call ballot harvesting. That's the loaded word. So again, you can get an absentee ballot, so mail it in, put a stamp on it. I forget if you have to put a stamp on it. Put it in. So the court was presented with these kinds of day in and day out voting provisions. What the Alito majority opinion did is strip those of any context, ignore the fact that, in fact, precincts change in Arizona all the time without much notice and much more often in minority communities than not. So it's very common for people to go to vote where they've always voted and all of a sudden they're in the wrong precinct. And the ballot collection, Arizona has Indian reservations, very rural places with barely a post office, with people don't have cars, there's no mass transit. And so it's very common for a community group or community organizers to collect the ballots from people who cannot easily get them delivered any other way. So Alito forgets all that and just says, like, what is the problem with this? The Elena Kagan dissent tells us what the problem is and uses these as emblematic for what you look at are the historic, cultural, ethnic, whatever context in which these provisions were adopted. And that matters when you're asked to determine whether they violate Section 2 of the Voting Rights Act. So that's basically where we're left to right now.
Jim Stark writes a question for you. He says, Justice Kagan accuses Justice Alito's majority opinion in the voting rights case of being a, quote, law-free zone. Do you agree that the opinion ignores the text and plain meaning of the statute and follows up what accounts for the court's hostility to the Voting Rights Act?
Well, I mean, it follows the text, but it wrenches the text out of the context in which that text was adopted. So to that extent, yes, I think Justice Kagan is quite right. And sorry, what was the second part of his question?
Well, he's asking what accounts for the court's hostility to the Voting Rights Act. I mean, I think we can guess on that, but go ahead.
Well, so let's go back to the early 1980s. So in 1980, the Supreme Court had a decision called Bolden against City of Mobile. It was a Section 2 case. And the court determined that Congress, in passing Section 2, had only meant to have a purpose test. If the plaintiff couldn't show that the provision they're complaining about was enacted for the purpose of suppressing the vote because of racial prejudice, they lose. Congress, in fact, had not meant that. And so Congress amended Section 2 to make it clear that it was not only purpose, but also results. There was a young lawyer in the Reagan administration Justice Department at that time who was given the portfolio to oppose this amendment. And if it passed, to get the president to veto it. His name was John Roberts. Okay, he was right off his clerkship with Justice William Rehnquist before Rehnquist became Chief Justice. And memos that Roberts wrote from that time came out from the Reagan Library when Roberts was nominated by President Bush in 2005 to be Chief Justice. So he had a problem with the Voting Rights Act, when he was in his 20s. And he's got some friends on the Supreme Court. And what exactly their problem is, I wouldn't venture to guess, but there's some real radical thinking going on that side of the court. There was a concurring opinion that hasn't gotten much notice, and I'm not quite sure I fully grip it myself, from I think it was Thomas and Gorsuch, if I'm not wrong, who said, by the way, this case never raised the question of whether there's an implied private right of action under Section 2. What that means, to translate, what that means is Can an individual bring a Voting Rights Act case? My voting rights have been impaired. I have a Section 2 claim. Does the statute contemplate that? That's something that I was unaware of is bubbling up there. But for two justices to highlight that, saying we can't decide that here because nobody's raised that, means that that's sort of next down the line. So there's a great deal of animus flowing in the waters on the Supreme Court on these issues.
And is the expectation that a court that is stacked this particular way, that has shown that it has this particular animus toward the Voting Rights Act as it stands, that as states continue to pass more and more restrictive laws, cases will be brought against them. The court has already shown they will take up said cases. And over the course of the next couple of years, we could see more and more instances of voting rights being stripped away.
Well, I mean, not to sound partisan about this, but I think this is an objective statement that I think that the National Republican Party has decided that the only way it can win elections is by suppressing the vote of people who might be voting against them. Okay, so you've got a huge motivation in the states to do exactly what you said. Now, counter to that is the fact that states also have courts. And we saw that in the aftermath of the 2020 election, that some state courts, like the State Supreme Court of Pennsylvania, actually put their foot down. And what they saw was efforts to undo the Biden victories in those states. So there are state causes of action that people can bring. And there are, we have the 14th and the 15th Amendment to the Constitution, one on equal protection and one on the right to vote, that people can come up with ways to actually invoke those amendments, not just the statute as interpreted by the Supreme Court. So I'm not at all trying to be Pollyanna about this, but we've got a complicated landscape. We've got very motivated people digging in against democracy, you might say. And we've got some very smart people working on ways to get out of this. And, you know, obviously the rational thing to do would be for some national legislation, which is pending in Congress, to pass. Doesn't look like that's going to happen. So it'll have to be done retail rather than wholesale out of Washington.
A last quick thought on this, a question from Jacqueline, who says, do you see it as a lost cause to fight these laws in court? As these laws, as I said, continue to come up, is it fairly clear that laws like this will continually be struck down by the court? Or can you see a window for some types of voting rights cases to actually get some sort of maybe split votes or bipartisanship amongst members of the court?
Well, we'll see that pretty soon, because the week before this case came down, Attorney General Merrick Garland filed a Section 2 Voting Rights Act case against the state of Georgia for the law that Georgia passed in January, February of this year. It was a very carefully written complaint, knowing that the chance of prevailing in the Arizona case that was then about to be decided was iffy. And so the very smart people in DOJ who wrote this complaint anticipated a bad outcome in the Arizona case and have tried to build the strongest case they can under Section 2. And, you know, maybe they'll get somewhere with that. That'll be really the, I hate to say ultimate, but it'll be major test, because you've got the power of the federal government now coming in and saying, you know, this is how we understand the law as it exists. Here's how we plan to use it to push back against what's been going on. And over to you, Supreme Court. So we'll see.
I have a question here from William. And again, if you have questions for Linda Greenhouse, you can type them in the Q&A function at the bottom of your screen. William says, I think studies have shown that conservative justices move left once they're on the court. Is that conventional wisdom holding true in your experience?
That is conventional wisdom. And there have been some interesting studies on it. And it was true in the old days. I think it's not very likely to be true in these days when every conservative justice has been vetted to fairly well by the Federalist Society, served up to the White House by the Federalist Society. The Republican appointed justices who tended to move left over time, say over beginning around the middle of the 20th century, tended to be individuals who had spent their careers outside of Washington, hadn't worked in the federal government, hadn't paid those kind of dues, were not such known quantities, were appointed for one reason or another that had to do with things other than an absolute guaranteed ideological position on this, that, or the other thing. But the whole nomination and confirmation process has become so ideologically inflected that I don't think we're going to see a whole lot of surprises going forward.
But is there something different as somebody who knows the people on the court, has watched the court for such a long period of time? Is there something that happens internally once people become part of this group of justices that we don't see that actually allows them to change in some way from the person that is put on the stand in front of the Senate Judiciary Committee answering questions as though they have, been vetted by the Federalist Society? I mean, is there something that happens when they're actually in that chamber talking amongst their colleagues that does shift positions and minds?
Well, I mean, that's interesting. I mean, not to sort of engage in pop psychology out of my silo, but I think the reason why those justices who have made their lives outside the Beltway, who come to Washington in midlife as Supreme Court justices, and it's got to be an experience that kind of shakes you up, shakes up your priors. Maybe you learn something. I think that's that very scenario that you posited is why you really see there's a dichotomy between among Republican appointed justices from the middle of the 20th century. Those who have drifted left have been the outsiders, have been David Souter, Harry Blackmun, Sandra Day O'Connor, Anthony Kennedy to a degree. Those who haven't changed have been the inside the Beltway players who make it to the court. I mean, John Roberts' commute when he was promoted from the DC Circuit to the Supreme Court grew by about 5 blocks, right? He had spent his entire life in DC. Sam Alito has never cashed a paycheck that wasn't written by the federal government, right? So Clarence Thomas was, I mean, we all remember his Pinpoint, Georgia, origin story, but basically spent his entire life as a federal bureaucrat. So, that's the difference. And I think now we're seeing people who are much more likely to hang on to the ideas that put them forward as plausible Supreme Court candidates in the first place.
I apologize if you've used that line about Alito before and I just hadn't heard it, but that's pretty funny, actually.
I have to say I've used it before and nobody has ever contradicted me on that.
You actually wrote a lovely piece about Justice Sotomayor called "The Truth Teller of the Supreme Court." And I'm just going to quote here. It says, on today's Supreme Court, she's fated to be on the losing side of many of the issues she cares most about. So her project, it seems to me, is to make legible for these times and in times to come the context for the court's decisions and the consequences likely to flow from them. Can you explain a bit more about why you chose to write about her specifically on the court?
Yeah, because she specifically has been the one calling the court out. There were a series of death penalty cases during this term. People may remember that Attorney General Barr announced that the federal government was going to start executing people, which it had not done for a couple of decades. And there was an amazing string of 13 federal executions. There were more federal executions in 2020 than there were state executions. I think I'm right on that. If I'm wrong, I'm just off by 1 or 2. So, the court was kind of Trump's enabler in that. if the lower court had granted a stay, the Supreme Court would vacate the stay. If the inmate came seeking a stay, the Supreme Court would deny the stay. And Justice Sotomayor was dissenting in these cases. And finally, in the last one, which was in January, I mean, it was 2 months after Trump lost for re-election, he was still executing people. This was a case, individual called Higgs, I think. She wrote a dissenting opinion that named all of these people who had been executed. It was sort of, it was her version of Black Lives Matter, say their names. She said their names, and she put it in U.S. reports, the formal, the formal record of Supreme Court activity. And I just thought it was pretty remarkable. So that's why I wrote that piece.
We're going to get back to some of the court cases from this term in just a second, but people have a lot of questions about other people on the court. And one of the questions that obviously you've been thinking about, and a lot of people are thinking about, is whether Justice Breyer is going to or should retire. Judy asks a question: does Professor Greenhouse expect that the liberals urging Justice Breyer to retire may cause him to act contrary to those strongly stated urgings? So what do you think Justice Breyer is going to do, and when?
Well, I have no inside information, but I think if he had been going to retire, he would have retired, because typically a justice will either announce planned retirement in late April, which is when the court finishes its argument sessions, or at the very end of the term, as Anthony Kennedy did in 2018. And of course, the other two recent vacancies were caused by death, Justice Scalia's death and Justice Ginsburg's death. So he would have done it the last day of the term, which was last Thursday. I think now, I'd just be shocked, because, motivation for giving the president advance notice is that you can get somebody seated by the time the court comes back into session on the first Monday in October. So do I think that the liberal beating up on Breyer caused him not to retire? Again, I don't know anything, but I think that's possible, that it backfired because it made it seem like such a political act. It kind of, even if in Breyer's mind it would not have been a political act. The man is 82 years old. He's been on the court for, my math is terrible, but I think he went on the court in 1995. He's entitled to retire, but it would look so political that it may have pushed him back. So again, I don't know.
It's so interesting, that is, I wonder if the people on the court who have been there for quite some time, they've obviously seen that it has become a very political place and very highly politicized amongst all of Washington and all of America, really. I guess I can't imagine he wouldn't be thinking, well, yeah, it's political. That's part of the gig. And if I don't go, then something else political is going to happen. Maybe in a year or so, in a couple of years.
You never know. Again, it'd be very presumptuous of me to try to read Stephen Breyer's mind. He's a very smart person. And, he made the decision that was right for him. Whether it's right for the court of the country, history will judge.
There's another question that we've gotten a couple different times, and it is very much a political question. It has to do with the question of court packing, whether or not the Democrats, or Republicans for that matter, if they were to gain control of Congress in such a way that they could actually do something like this, would be incentivized to increase the number of Supreme Court justices so that they would create either, if it was Republicans, a permanent majority, more or less, or if it was Democrats, balance things out once again so that there's not a permanent conservative majority. How do you view that idea as political, clearly, as it is?
Oh, I understand it, and the extreme frustration of the stolen seat that should have been President Obama's to fill, that McConnell blocked for 10 months. I've been agnostic on a lot of these ideas. So I don't actually have a very fixed view of it. The president has this commission with 36 very smart people on it. They were going to come up with some consensus idea, I guess. And I think a lot of people got an invitation to submit whatever ideas I might have to the commission. And I actually did not accept that invitation because it's just not something that I'm not confident that I have a good view one way or the other on that.
I'll just follow up with you on that, just because I guess I'm wondering if you feel as though having 11 justices or 15 justices would irrevocably change something about the way the Supreme Court of the United States functions. And I'm not asking you to put a value judgment on it, but more just how do you think that would change what the Supreme Court is and what it does if you added a few more justices to it?
Oh, I don't think if you went from 9 to 11, it would make a big change. You need a place for them to work, but that's another issue. If you start going to 15, no, I think it becomes, they'd have to start sitting in panels like the appeals courts do. I mean, I think an interesting change actually would be not to grow the court, but to shrink the court to an even number of justices, which was the original plan. The first Supreme Court, which was built by George Washington, had 6. The number of justices have changed, I think, 7 times over the country's history, although not recently. But during the year after Scalia died, when President Obama was blocked from filling that vacancy, and they only had 8. The court really did seem to be trying to reach consensus on a number of things. That did change the dynamic. And, whether it would be 8 or 10 or, 6 or whatever, if I were kind of redesigning the court, I would give serious thought to an even number of justices.
See, that's the kind of answer I was looking for. I was looking for the if Linda Greenhouse could redesign the court answer, and that in a lot of ways makes a lot of sense. And I'll just ask you to quickly expand upon that for another second. Are there other ways in which the court could be altered in some way that would make for a better democracy, make for a better outcome for all of America, not in a partisan way, but just make it work better?
Well, one other idea that is kind of floating around is suppose there was a requirement that before the court invalidated an act of Congress, it could only do so by a supermajority, by 6 out of 9. So you wouldn't have 5-4 to strike down Obamacare or whatever. And I think Congress has the power to do that. The Constitution gives Congress a lot of power over the court's jurisdiction and procedures. So I think that's kind of an interesting idea. And then of course, people talk about term limits, because life tenure for high court judges is very, very unusual in the world. In fact, it's unique in the world, as far as I know. Of course, that's not a fix for the current problem as perceived by Democrats, because you couldn't cut off the terms of the incumbents, and so you're talking, long-term kind of rolling fix, assuming it could be done by legislation at all, which is a big debate. Would it need a constitutional amendment? So, that's an interesting talking point, but it's not a practical solution to the current set of problems.
You mentioned Obamacare, so I'll ask about that. They didn't strike down Obamacare again. Is that about the end of the attempts to take Obamacare or some version of Obamacare to the Supreme Court and have it be invalidated?
I kind of think so. I'm too. The political dynamic has changed. So there's really, people like Obamacare, so there's really nothing in it for the Republicans to keep demonizing it and undercutting it. And if anything, I think the public wants to beef it up and make it more robust. So yeah, I think that's probably over.
Can you talk about the California case that has to do with political contributions and whether or not we get to know who's making those political contributions, and what do you think the ramifications of that case are?
I think they're large. This is part of what Justice Kagan calls the weaponization of the First Amendment. So the claim is there's a First Amendment right of association that is impaired if you have to disclose who you are and making a charitable contribution. And this was not a case about politics, but it was a case about the Constitution, and the Constitution would apply, it seems to me, to disclosures for political contributions too. These were contributions for 501c3 charities. So, part of if you remember Citizens United, which I suspect people do, part of the deal there was the court said, well, we can't stop the flow of money because people have a First Amendment right to spend money in politics, but at least they'll be disclosed. Now it looks like maybe not, or quite likely not. So that's something the political system is going to be dealing with. That's the whole dark money problem. Now, I have to say we already have a dark money problem, because if you look on the IRS Form 990 for any nonprofit, and I looked at those pretty regularly, actually, they're all online, because I hear about some outfit and I think, okay, so what do they do with their money and where do they get their money? You really can't tell the answer to any of those questions. So we're already living in an age of dark money, and it's just going to get bigger and darker, I think, because of this.
Sarah Stroud asked a question that I think we talked about a little bit, but I'd love for you to talk about, because I was very interested in this when we talked last year. She says, I remember you talking on last year's broadcast about changing jurisprudence around religion as a major goal of the Chief Justice. Can you talk about how that advanced and moved on this year? Last year, when Lynn and I talked, you talked about the Roberts Project having to do with religion. And as we started our conversation tonight, we did talk about the importance of religion, but maybe you can bring that up again, and the John Roberts influence on the religion project as you talk about.
Yeah, I mean, it's interesting that this is a case where I think he has been a bit outflanked to his right by people that have an even bigger religion project than he does. So the question is how society evaluates religious claims that create third-party harm, people that don't share those religious beliefs. I mean, I think that's really where the rubber meets the road. So that was the Hobby Lobby case. Mr. Hobby Lobby is saying, I can't possibly go along with including contraception in my health plan, and he got away with that. So as a result, the women working there don't have the right to that was granted by Obamacare to all women to have their birth control covered by their employee health plan. That's what I mean by the third party harm. So there's been this big push to overturn a decision, a 1990 precedent called Employment Division against Smith, that seemed to be what the court was going to be about this term. Employment Division against Smith said that when you've got a law, a neutral law of general applicability, that is, say, a law that was not passed to impair religion at all, just a law, you don't have a religious right, a free exercise right under the First Amendment to an exception. That's been the law. That was the law before, actually, but it's been the law under Employment Division against Smith. So the court did not, in fact, overturn Employment Division against Smith in the case that it decided this term, a case called Fulton. That, I think, misled a lot of people into saying, oh, okay, the court didn't do it. So, they didn't do much. As I read that case in combination with the COVID capacity cap cases on communal religious worship, what I see is a situation now where you don't have to overturn employment division against Smith. You have already elevated religion to the extent that any difference in how religion is treated, a difference between religion and secular treatment. Oh, you're capping church attendance, but you're not capping, the grocery store, and that's discrimination. What the court did this term was expand what I would call the sort of common sense notion of what is discrimination on the basis of religion, made it basically everything, as long as there's a jot of difference between how religion and non-religion is treated. So, and once that happens, then the government is put to a very difficult, what's called strict scrutiny. They have to show that this difference is serving a compelling interest in as narrow a way as possible. And that's why the church won in the Philadelphia case, the way Chief Justice Roberts interpreted the contract to be not a contract of general applicability. So it was really kind of in the weeds, but I think we're going to be living with, even more than the past, the kind of elevation of religious claims above the other claims that are part of civil society.
And is the expectation that we will also see the court assuming that more people's religious claims are indeed valid religious claims, because certainly within the political media, we've seen a number of cases that have come up over the course of the last several years in which people are claiming religious rights. And if you look into it pretty closely, it's not really religious rights that they're claiming, it's something else, but using religion allows you new latitude, it seems, within American society.
Well, I think that's part of it. And also part of it's not that subtle. So the court actually has accepted for argument and decision in the next term another case about channeling public money to religious schools. And, if you move back, decades ago, this was an issue that was fought out over, textbooks or buses or supplies or this, that, or the other thing. And now it's just frontally out there. There's a tuition assistance program in the state of Maine, and you cannot limit it to secular schools. Religious schools have the, exact same right to feed at the public trough, and that's the thing, really radical in terms of our cultural history. But the court has gone so far down that road that there's almost nothing surprising about that inevitable outcome anymore. And, it just seems to me it would behoove us all to take a deep breath and think about that. Maybe we think that's great, but it's kind of happened on our watch. And I think it just has a lot of implications about, as I say, civil society and who gets to call the shots, the secular forces or the religious forces.
We just have a few minutes left, and I want to look ahead a little bit to next term, and we have a bit so far. You've mentioned some of the cases that are going to be on the docket for the court next session. What do you see as the highlights? It's going to be with abortion, with Second Amendment rights being at the headline. It seems as though it might be one of the most contentious courts sessions of all time.
Well, I think so. And you throw in religion and you throw in maybe affirmative action. And it could be pretty head spinning. We could emerge a year from now into, quite a different world.
Well, what is the specific challenge to Roe versus Wade as the law of the land that we see coming in the fall or next year at this time?
Yeah, so this is a case from Mississippi. It's a challenge to a law that prohibits abortion after 15 weeks of pregnancy. Pregnancy is 40 weeks, and the law since Roe against Wade has been that before the point of fetal viability, a woman has an absolute right to terminate a pregnancy. You can make her jump through a whole bunch of hoops. You can have a waiting period. You can have mandatory counseling. You can, make her stand on her head for 3 days or whatever. But at the end of the day, it's her choice. So you've got a 15-week ban. Viability is 23 weeks, 24 weeks. So you're talking about several months later. If the court were to uphold that law, and of course the lower court had to strike it down because it's flagrantly unconstitutional under current law. But if the Supreme Court were to change current law and get rid of the viability firewall that protects the right to abortion when basically all abortions take place, there'd be no stopping point. So Texas has just passed a law that bans abortion after 6 weeks of pregnancy, a time which many women don't even know they're pregnant. It could go down and down and down, and there would quickly be nothing left to the right to abortion as a federal matter.
The Second Amendment case, of course, is also so very important. While abortion as an issue is an undercurrent in American life for the last several decades, and it tends to spike around Supreme Court cases and around political appointments, gun deaths in America seem to spike a couple times a week. I guess I'm wondering how you feel the court, and you've written about this in the Times, Linda, how you think the court will grapple with important Second Amendment issues coming up next term, at the same time that we will almost undoubtedly see people walking into supermarkets, walking into schools, shooting people in broad daylight over and over and over again, as has been happening in America repeatedly over the course of the last several decades.
Yeah, well, it didn't deter them. I mean, the court granted this case in mid-spring. The day before they granted the case from New York on open carry. The day before they granted it, the big headline in the New York Times was "Third massacre in 3 weeks" or something like that. That's not a deterrent to people that really, I mean, it's their secular religion is the Second Amendment. So this is a challenge to a New York licensing scheme for gun licenses that says that to get a gun license for, every day walking around with your gun, you have to show some special need that distinguishes you from just the general population. And so the claim is that requirement violates my Second Amendment rights. Now, it's a minority of states that have that requirement. Most states don't. If they say you have to get a license, they don't say, you can walk in there and say, I want a gun license. So give me a gun license. So if the court were to uphold, if the court were to accept the challenge and say the New York law violates the Second Amendment, it wouldn't change life as we know it on the ground for most people, for most gun owners or gun owner wannabes, but it would open the door, the gate to a much broader understanding of the Second Amendment than we've ever had in this country.
Before we leave, can you just give me a minute or so on the book that you have upcoming in the fall, Justice on the Brink, based around the death of Ruth Bader Ginsburg and the way that the court has transformed over the course of the last year?
So it's a chronicle of the term that just ended. This was my pandemic project. And the book chronicles month by month what happened, not case by case, but kind of theme by theme, chronologically, and that's what it is. And so it's kind of it's not, I don't tell it in the first person, but it's obviously my view as to the significance of what's been occurring. A lot of what we've talked about tonight. My challenge now is to kind of wrap it up into the last chapter. That's what I'm up to.
Has this been the most momentous year of your life in covering the court?
I mean, after 40 years of covering the court? No, I wouldn't necessarily say that, but it certainly has been a fascinating one. And, one that nobody would have anticipated with this one-term president having made 3 Supreme Court appointments. So, it's a big deal.
Well, it's been a fascinating hour, as always. Linda Greenhouse, of course, the longtime writer and reporter for the New York Times. Her book, as I said, is coming out later on this year. It's called Justice on the Brink. Linda Greenhouse, thank you so much for being with us. Thanks for answering all of the questions from our audience, and thanks for supporting the Connecticut Mirror. Thanks,
John. My pleasure.
If you want to support the Connecticut Mirror, you can go to ctmirror.org and just click on that little donate button. It really actually makes a lot of difference. We can't have in-depth, high-quality, nonprofit, nonpartisan journalism without your support. I want to thank all the readers of the Connecticut Mirror who joined us tonight, and all the readers of Vermont Digger who joined us as well. You all understand how important it is to have news that you can trust. Please do support it if you haven't already. Thank you so much for joining us. If you go to ctmirror.org/events, you will be able to see a rebroadcast, as it were, of this event, and also some of our past conversations over the course of the past several months. And you can listen for an edited version of this conversation on our podcast, Steady Habits, coming up in the next couple of days. Thanks again so much for joining us. Please have a good night.